So I have been asked to speak on medical legal risk in ophthalmology. So my topic is not as interesting as Hitesh's, because Hitesh has been, Hitesh has a multiple talents. He's a singer, he's a songwriter, he's into plays. I think so. He can make a lot of things funny. I am only a lawyer, and I can only talk law and walk law, and hence my presentation is going to be a hardcore medical legal presentation. And the presentation which Hitesh did was extremely interesting, and telemedicine definitely is the hot topic right now for all of you, and especially in times of COVID, this is something which you all should consider. And but before you could do that, let us also see what exactly is what exactly could be the medical legal problems or medical legal issues that may come in your way. So and I am going to also take you through some basic principles of negligence, and I will also talk about some of the importance of a consent taking in your practice, and also about the documentation. So, and my presentation is not very big, and towards the end I will share with you some case laws very briefly as to what are the compensations that the Supreme Court and the national commissions have been granting. So if you feel that the ophthalmology is a very safe practice, then I think so you should reconsider your views post the last slide that I actually show. Okay, so we are living in the COVID times, and there could be a lot of issues pertaining to your day-to-day practice. I think so all the medical practice, whether it's a pulmonology or whether it's a gynecology or even ophthalmology for that matter, has undergone a paradigm shift. I don't think so you will ever be able to practice again, at least for some times to come, the way you used to practice in the month of January and February. Because March onwards, I think so all your protocols and SOPs will start changing now. Yesterday only, the ICMR and the Health Ministry has issued a detailed SOP on how the ENT practice should be conducted post COVID. So uh, I think so all the other practice areas also will see some guidelines coming out from the health ministry. But nevertheless, ophthalmologists are at the huge risk, because you deal in close proximity with a face of the patient, and you deal with the most important organ, that is the eye. And it is also known to carry the COVID infection goes into your body through eyes. So there are a lot of things that you do which definitely would impact the practice. So you need to take care, because you are in close proximity. Ophthalmic equipment also can get contaminated. So you have patients have tears, droplets. So there is lot of fluids which come out of the eye sometimes, which could contaminate. Plus all these things of lockdown and everything, not going to work or restrictive practices, has caused a lot of anxiety and depression, and people are concerned. I think so your association itself conducted a survey recently online, and I think so the result of it was that there are a lot of people who are really, especially youngsters, freshers, who have just started practicing, are really worried about the future of the practice. There will be definitely an impact on your practice areas post lockdown. You will see initially the number of patients go down. Elective surgeries will also get affected. People would, I've just heard from some opthal friend today morning that people are refusing to get operated, and things are very difficult for them to convince that how you have maintained the standards. So there are a lot of things which could happen in this time. And when you are in such situation, there is always a possibility of someone suing you for medical negligence. And that is a time when you need to be very sure as to what you're doing, and your conduct should be above the board during such times. So let us see in brief what is medical negligence. So medical negligence, in a simple word, is basically uh, you know uh, the doctor deviates from the standard of care generally imposed by the society and expected from doctor, he shall be liable for medical negligence. The Black's Law Dictionary says that the medical negligence is also defined as failure of doctor to exercise the degree of care and skill that a physician or a surgeon of a same medical specialty would use under similar circumstances. So these are the two simple definitions of what is medical negligence. Medical negligence is a vast subject. I'm sure Hitesh would agree with me on this, and it would take a whole day. There are conferences which are conducted for days on medical negligence. So summarizing it in one side is very difficult. But what is a test of medical negligence? The Supreme Court and there are various judgments, and there are plethora of National Commission judgments which set out the test for medical negligence. So, what are the three main ingredients of medical negligence? Number one is the doctor owed a duty of care to the complainant. Here, the complainant is invariably your patient. uh, the second ingredient is the doctor was in breach of that duty. So there has to, number one is that the doctor should owe a duty of care. Second is that the doctor should be in breach of that duty. And the third is that the complainant must suffer damages as a result of that breach of duty. So all these three needs to be linked in one simple straight line. So if either of these three things is missing, then it is not. It will be very difficult for the complainant or the patient to prove that you are negligent. So courts are very wonderful places. In spite of all these things, anything can happen, primarily because we don't have doctors who are practicing doctors as part of the judicial system in the consumer forums. There are very few of them. So normally that is a big problem. While dealing with the medico legal cases, the judges sometimes don't understand the finer nuances of medical practice. So that's why, in spite of the clear law, there could be some mistakes from the judicial aspects also. Now, what could be, what are the various examples of medical negligence on which probably you could face in your practice? Okay, number one, I feel is most of the times medical negligence occurs when there is a breakdown of communication between the doctor and the patient or the team of doctors. So, what we have always seen is that if you have a proper communication channel, then at least 40 to 50% of your medical legal problems come down for only because a patient actually gets aggravated, or patient gets agitated only because there is no flow of communication. I'm sure you must have heard a lot of friends talking about how someone is admitted in a COVID hospital and there is no communication from the doctors or the BMC for days. How anxiety builds up and you get tensed. Similarly, in the normal circumstances, if you don't talk to your patient or give them information sufficient for them to be comfortable, then they are bound to feel agitated. And that is where the seed is sowed in the mind of a patient that there is some problem with this doctor. He has an attitude or she has an attitude, and hence we need to teach them a lesson. And that is where actually they start discussing their medical legal issues with some doctors. Invariably you have there is a big industry called second opinion industry that I call by that I always refer to, is that there are too many doctors who are willing to give some second opinions and instigate a patient as to अरे ये तो मैं होता तो ऐसे करता, इसने ये ऐसा किया ना, ये गलत किया है. So that is also adds to the that is like adding fuel to the already lit fire. Then it also could be lack of verification procedures, like incorrect IOL power, then inadequate validation of site marking procedure. Example can be surgery to a wrong eye, inadequate preoperative checklist, incomplete patient assessment. Language barriers would also be if you're practicing in some other town or some place other than your hometown. Then language barriers also could lead to a lot of misunderstanding. Improper consent. Not taking a proper consent can also be a problem. For that matter, not taking a consent in itself is considered to be a medical negligence. It also is considered to be a breach of professional code of ethics. And those professional code of ethics are law in itself, and breach of them could land you before the state medical council medical ethics committee, which deals with such cases. And obviously failure to maintain proper records, this will not be able to prove any case. So if you don't have any records, you don't have any case. Records are the only things that will win a case for you. So that's the reason why we say good case, good records. No records, no case. So this is very as simple as that. The more records you maintain, proper records you maintain, the better for a lawyer or anyone to fight your case in case there is a problem. Now, let me touch upon informed consent very briefly, because I feel consent is a very important aspect of any doctor's life, and I feel it is extremely important that you understand that consent has originated. It has origin in the law. It is not a document which me or Hitesh or any other medical legal expert is just telling you to do. No, consent is something which is also there mentioned in your medical code of ethics. It is not figments of our imagination. It is not a lawyer's creation. It is something which your professional code of ethics also mandates you to take. And plus, not taking a consent is a open and shut case for medical negligence or even breach of code of ethics. So the landmark judgment which Supreme Court gave is Samira Kohli versus Dr. Prabha Manchanda. It was a 2008 case, and it has laid down a very clear law as to the consents, and it is important that we take consent little seriously. A medical practitioner, before performing an operation, should obtain a written consent from husband, wife, parent, guardian, or in case of a minor, or the patient himself, as the case may be. So you need to take a consent at the right time. I would always advise you to take a proper consent, before sedating or before putting any drops in the eyes of the patient before a surgery. Ideally, you could also give a consent a day or two in advance, so that patient can actually read the consent, understand it properly, and then come to you with proper questions. Because understanding a consent is also one of the criterias that you need to meet, and that is also mentioned in the Supreme Court judgment, the Samira Kohli judgment. So sufficient information should be given. The judgment says that the sufficient information should be given so as to enable a patient to understand what he or she is going through. So which means that if you give a consent to read to a patient a day or two in advance, then that would be really a very good practice. This is what is done even in the other countries, that the consent is given 2-3 days prior to the surgery, so that the patient gets sufficient time to understand, and then come on the day of the surgery to then they can discuss it with you, ask you the questions, and then they can sign it in a conscious state of mind. Failure to do so shall constitute professional misconduct on the part of the physician, rendering him or her liable for disciplinary action. So, this is we I have just said that. Now, something more with the consent. Ignorance of law cannot be defense in the court of law. Hence, every medical practitioner must be aware about the significance and the process of consenting. So, a lot many a times I ask this question. We are not in an open one-to-one discussion, but one question that I would always want to know from you is that who would you ask a consent to be taken? A receptionist sitting at your counter, or it will be taken by yourself, or someone who is going to be your technician. So who will be the one who should be taking the consent? That's a question that you need to ask yourself. I know the answer. I want to know whether you know the answer or no. So consent is what? Consent is like a contract, okay, and where two or more persons agree upon same thing in same sense, okay. So consent is a contract. In one of the judgments, Supreme Court has very clearly mentioned that consent is like a contract. So hence, it is a very important document. Consent should be taken in writing and should always be informed. So that is what I mentioned earlier. Patient should have sufficient information. Now, it doesn't mean that you start narrating the entire story, or you don't have to tell the patient about all the remote complications. You need to mention to the patient the immediate and serious complications. You don't have to mention the remotest complication. So that is not something that law expects from you. Blanket consent has no legal value, so you cannot just take a printed format downloading from some Google or some website, and you can say that अरे मैं तो सब standard है. ऐसा नहीं है. Blanket, I've seen so many judgments of the National Commission which very clearly says that blanket consent is not a proper consent. So hence, you need to customize a consent based on the procedure that you are doing. So in short, it should be a procedure specific consent. That is what I'm trying to tell you. Consent provides a medical practitioner legal protection, so please take this seriously. And if you are not taking consent so far, I think so it's high time that you start taking consent. I'm sure most of you do it. It is a very basic document. Every doctor must be doing it. But for any reason, if you feel that in ophthalmic practice, if you don't need a consent, then I think so you should rethink your decision. Now, maintaining of records. So I have seen a lot of ophthalmologists who don't maintain complete records. I'll tell you the reason I feel is that because it's not one of the main, it's not one of the branches which is sued very often. But well, I don't have authentic data, but some of the data on the internet suggests that surgeons are among the maximum sued. Now, surgeons can be any surgeon. It could be a general surgeon, or it could be a eye surgeon also, basically. But nevertheless, papers are the ones which will save you, whether you are a gynecologist or whether you are any other logist or a pathist or a doctor. What matters is that a court will see a record, and if you show a proper record, that's the only way of protecting you. So you need to maintain the records for 3 years, which means that you need to keep the records for 3 years. This is for individual doctors. Medical code of ethics says that you need to maintain it for 3 years. That is what it's very clearly given in that. So you're bound by it. Then you need to give, if someone asks you for the records, you must give the photocopies of the records, because a patient has a right over his own records. You may charge them for the photocopying, or you may take precautions before giving the photocopies, but you must give the records within 72 hours. That is also there in your professional code of ethics. It's not something that I have put it on myself. It is something which says it is part of your professional code of ethics. Now, maintaining a register of medical certificates is also mentioned in your professional code of ethics. So, if you have given any certificates to anyone, for that matter, for the vision or for the eyesight, so especially you land up, giving certificates certifying the vision of someone. So, you need to maintain a separate register for those certificates. Those are also that also is part of your duty under the medical code of ethics. So records are something which you must take it very seriously. Like I mentioned, 94% of the surgical complications are the most common cause of malpractices claim, and one study puts this figure up to high as 94%. Surgical record should be meticulously written, recording of all detailed complication with their management. So it is something which is up to you as to how detailed you can go in, how much time you have, or if you have a mechanism for writing papers, you can use those. You have now softwares. You can use proper you can take help of junior doctors, or you can take help of someone specially appointed for writing your case papers. If you have a big practice, if you have a consistent practice, or if you have a huge turnover, then I think so it's high time that you invest in someone who could actually help you in writing your records properly. So, what type of records you should maintain? Informed consent, obviously, is you should also record the refusal of treatment or investigation if the patient is adamant, and if he doesn't listen to you, then that also should be recorded in the case paper somewhere. All the investigations should be maintained properly. Operative details also needs to be maintained, like details of type of surgery, date of operation, date, operating surgeon, anesthetist, and all the other details also should be mentioned. Discharge card, a discharge summary, if you have admitted someone, and if the surgery is there, and if at the time of discharge, may give a proper discharge certificate, or a discharge card. Fill that up properly, clearly mention when the follow up has to be done, what are the emergency signs that they should look out for, or in case of an emergency, who they should contact in your clinic or in your practice. Someone who is at a point of contact person, that name or details of the phone number also can be given. That's just part of being good to a patient, and to be little bit more on the safer side, you can do all these things. Obviously, or you should also maintain referrals. you know who has referred you, the patient, and why he has referred you or she has referred you, probable diagnosis and the condition at the time of referral. History taking, according to me, is a very important aspect for avoiding any future complications as far as law is concerned, because try to spend some time on writing a proper history. As far as possible, the history taking should be done by the doctor himself, because I have seen that you keep a printed form or a software tablet is given to a patient outside the doctor's chamber, and the patient is the one who fills in the history. Now sometimes patients don't understand the seriousness of that history sheet, so I have always noticed that sometimes patients don't understand, they write wrong things at the wrong places, or they don't write anything at all. And the girl or a man sitting at the reception of your clinic doesn't have the depth or the value or the importance of why history taking is important. So I feel history taking before any surgery, whether it's a cataract or a LASIK, anything you do, I think so history taking is extremely important, because the condition of the patient at the time of treatment, that is the time when you touch a patient, what was his condition, that is something which you should absolutely know, because you could also find some comorbidities in the patient at the time. And if tomorrow this things gets overlooked and if there is some complication, then tomorrow the patient should not say that मैंने तो बोला था डॉक्टर को कि मेरे को डायबिटीज है, बट उन्होंने फिर भी सर्जरी किया, so we need to know exactly what are the kind of histories that he has, and be very specific in what you want. You can create your own history sheet. You don't have to copy anyone's, or you don't have to download anything from from internet. Even if your association has given you one standard document, that's also fine. You can modify it, you can add something to it, but nevertheless involve in history taking process yourself. Now, this is the last part of my slide. Now, these are some of, there are a lot of cases, but these are some of the cases which I thought that I must share it with you. So the first case is basically for 50 lakhs, National Commission has awarded this, for 50 lakhs, where a LASIK surgery had gone wrong. The cases are huge. There was no point in discussing the cases, but I have given the citations. If you do a Google search, or you can go to some of the websites, you can find the judgments, you can read it yourself. The second case may not necessarily, it's not directly related to ophthalmologist, but but there were a lot of doctors who were involved in this, and this is the judgment which came out in 2019, which was a Supreme Court case. Justice Uday Lalit and Indu Malhotra were the ones who delivered this judgment. It was given 76 lakhs were awarded for for missing out on the ROP test, which was to be carried out on the baby, and who was born prematurely. So the baby was discharged with ROP stage 5 in both eyes, and that's the reason why the Supreme Court found that there was negligence on the part of the doctors. And this was a hospital. This Maharaja Agrasen Hospital is a Gurgaon-based hospital, and this is the probably the latest case before the lockdown, which was in 2019, and after that, the lockdown really started. There was this is Supreme Court case, so this is one of the leading cases. It also talks about vicarious liability. It has upheld the earlier decision of the Supreme Court, saying that the vicarious liability is a doctor or a owner of a nursing home or a owner of a hospital or a clinic is vicariously liable for the acts and deeds of anyone who is working under him. So they have reiterated this in this case. And the third and the final case is basically the State Commission of Delhi, which has awarded 35 lakhs to a complainant for a loss of the eyesight due to medical negligence of the hospital. So this was also State Commission ka hai, so I'm sure they must have gone in an appeal in the National Commission or in the Supreme Court subsequently. I'm not aware about the latest things about the last case, but yes, this is what I found. And so it's not that ophthalmologists are not sued in the country. Ophthalmologists are sued in times of COVID. I think so what you need to do is take sufficient care, and you must ensure that the care that you're taking is demonstrated in in the form of posters, in the form of literature, whatever you're calling your patients to your clinic. I would suggest that you send them in advance the kind of checklist that you want them to follow. Whether they should get their own mask, whether they should sanitize before coming to your clinic, whether they should wear if you're doing a surgery, whether you should decide whether a patient is also going to wear a PPE kit, or whether you need to have some special equipment for sterilizing. All those things that you need to do, you can create your own checklist, you can give it to the patient prior to the coming, and then subsequently that show, if something happens, is irrespective of so much of precaution, then I don't think so it is your fault anywhere. You will not be held responsible for medical negligence. And hence what matters is taking of care. That's it. Thank you very much, and I really would like to thank everyone for inviting me, and it was really a pleasure talking to all of you. Thank you.